This is Syndication Attorney Field Notes. I'm Tilden Moschetti, and I'm a syndication attorney. Today's field note is about the difference between a real estate syndication and a blind pool fund when both are raised as Regulation D private placements. Here's the scenario. A sponsor calls me and says, Tilden, I'm tired of chasing money one building at a time. I want to raise a fund so I have cash ready to go. And then comes the line I hear almost every time. It's basically just a bigger syndication, right? No, it really isn't. So here's the direct answer. A syndication and a fund can both rely on the same Regulation D exemption. That part can look similar, but they are not the same legal container. A syndication is built around one known asset. A fund is built around the sponsor's strategy. That single shift changes what you disclose, what investors are actually buying, and even which laws might apply to you. Let me start with why the mistake is so tempting, because the business logic is completely sound. If you've done a few syndications, you know the friction. You find a great property, then you start passing the hat, racing to fill the equity before escrow closes. Every deal is a fresh raise. Sometimes you lose the deal because you couldn't promise the money fast enough. A fund fixes that pain. Instead of raising against one building, you raise a pool of committed capital. Dry powder, sitting ready, so the appeal is real. But here's the thing I want you to hold on to. Business flexibility does not equal legal simplicity. Solving your acquisition problem does not mean the paperwork just gets a little longer. The thing you're describing to investors becomes something different, and that's the distinction that matters. In a single asset syndication, your disclosure document, the PPM, wraps around a specific building. You can describe the property, the market, the budget, the pro forma. If the roof is near the end of its life, you disclose that roof. The investor is underwriting the real estate itself. Now take the building away. In a blind pool fund, there is no specific property yet. So the PPM can't describe a building. It has to describe your criteria, what asset types you'll buy, what markets, how much leverage, how much you'll put into any single deal. In a fund, the strategy becomes the asset. And here's the part sponsors miss. Those criteria are not marketing language. Once they're in your offering documents, they become operating boundaries. Think of it this way. In a syndication, investors underwrite the building. In a fund, they underwrite the sponsor. Let me make that concrete. Say you've been raising one Texas Class B multifamily syndication at a time. You decide to raise a fund. Your fund documents say Texas Class B multifamily with stated leverage limits and concentration limits. Good, clear. Now, 6 months in, deal flow slows. That committed capital is sitting idle. The pressure builds, and a friend has a syndication that needs equity, so you think, I'll just park some fund money into his deal to keep it working. Stop right there. When you buy a stake in someone else's syndication, you are no longer buying real estate. You're buying a security. Holding a deed is different from holding shares. And that one move can pull your fund out of the exemptions that keep a real estate fund from being treated like a mutual fund. Pooling investor money to invest in securities and advising on that for compensation can start to look like the business of an investment advisor. I'm not saying every real estate fund is an investment advisor. It's not. And I'm not saying you can never do a fund of funds. You can when it's built for it. What I'm saying is this, a fund does not automatically stay outside investment advisor rules just because the word fund is on the door. What the fund actually buys can change which laws govern you. So let me give you a few things not to assume. Don't assume a fund is just your same syndication documents made bigger. The disclosure object is different. Don't assume diversification means safer. That's an LP marketing idea, and putting safer or lower risk in your materials can come back on you if the whole portfolio takes a hit at once. Diversification is a strategy you're pursuing, not a guarantee you're offering. And don't assume the filings are one and done. A syndication is often a single Form D and your state notices and you're finished. A fund usually stays open for years. That can mean amending your Form D as facts change and keeping up your state blue sky notices as you take investors from new places over time. It's a maintenance obligation that runs the life of the offering, not a single filing. So here's the field note. A fund is not a promotion from a syndication. It's a different vehicle for a different situation. A fund tends to fit when you have predictable deal flow, enough volume to actually deploy the money, and a track record investors can underwrite, because in a blind pool, your history is the product. A syndication is often the cleaner structure when the asset itself is what investors need to evaluate. Let your pipeline dictate your legal structure, not your ambition. The right container is the one your real deal flow and your real track record can support. The longer written version is in the show notes. This has been Syndication Attorney Field Notes. I'm Tilden Moschetti.